see you. Dennis, good to see you.
Okay.
You want some water? Are you okay?
Oh, I have the water bottle. Thank you.
You came prepared. Look at you. Look at you.
All right, everyone, we'll get started. Thank you for coming tonight. It's really wonderful to be here. My name is Amy Bankoff. I'm an estate planning attorney, and I focus on trust administration and probate, and specifically wanting to help people plan while they're alive so that upon their passing, everything goes smoothly and there are no great conflicts and it's efficient and as inexpensive as possible. So a little bit about me, before we get into this. I'm 47, I have 2 children, a boy who's 20 who's here in town and a daughter who's almost 19 on Saturday. And I went back to law school when I was 42. So I've only been practicing officially for about a year. But I became passionate about estate planning because my son's father, 20 years ago, more than, passed away unexpectedly. And he thought that he had his affairs in order, and he didn't. And the result was an almost 7-year process that went between 2 different countries. 17 different lawyers became involved. $1.2 million in legal fees was spent, and the US government took 50% of what was left. And everything that his father worked for was destroyed. This beautiful vision that he had, none of it came to fruition. And so that's what moves me to do this work. And I was very fortunate that even though I've only been an attorney now for a year, I've been working with another wonderful attorney here in town who's in her mid-70s since my first semester of law school. And I get to be her wing woman. And so I feel very fortunate, and I feel very destined to do this work. So, as we get into today's presentation, this is just a little disclosure. I want to make sure I tell you that this presentation is provided for general informational and educational purposes only. It is not intended as legal advice and should not be relied upon as such. Every legal matter is fact-specific, and attendees should consult with their own attorney regarding their particular circumstances. Attendance at this presentation does not create an attorney-client relationship with me or my law firm. Okay? So, why does estate planning matter? We are here in Isla Vista, where we know we've got a younger population, and one of the things we're trying to communicate is that if you are over 18, you are legally an adult, and no one automatically has the legal authority to make medical or financial decisions for you, not even your parents. And a lot of young people just assume if they're in a car accident, oh, mom and dad are just gonna take care of it, right? And it's just not that simple anymore. So estate planning is how we decide who can act for us when we can't. And beyond that, after our death specifically, what we want to have happen. So here in California, when you have a medical emergency, for example, your doctors won't speak with you, and your financial life can spiral out of control very easily. And hospitals have to follow the HIPAA privacy laws, and banks will require written authority. So this is how estate planning, again, it allows each of you to determine who's going to have that authority, because you might not want your parents to have that authority, even though they might be the ones that are next in line to do that. So these are the general parts of estate planning that we focus on. We just were speaking a little bit about healthcare, which gets to advanced healthcare directives. Financial matters that we were just talking about, credit cards, daily bills, things like that, have to do with having a power of attorney. Some of us have already talked about what it means to have a will here in California, and we're going to talk about how that's a good thing, but it's also not necessarily enough. To avoid what is up there is probate. And short little understanding what probate is, if you don't know, is it's the court process that you have to go through for the court to approve of how things are going to be taken care of. Okay? So the final thing that we're going to talk a little bit about tonight are trusts and how effective those are at staying out of the court and avoiding probate. So first thing we're going to talk about are advanced healthcare directives, because again, this applies to everyone, no matter exactly how old you are, as long as you're over 18. An advanced healthcare directive, it gives you the ability to name your healthcare agent, and it allows you to provide very specifically of what you want to have happen if you become incapacitated. Do you want to be on life support? Do you want extreme measures taken to prolong your life? Or do you not? You know? Do you want to be an organ donor? Yes, that can be on your driver's license as well. But we want to be able to provide your agent with the information so that the doctors and the hospitals are not left unaware of what your wishes are in an emergency situation, okay? So, advanced healthcare directives, we create them, I create them. There are also some very standard forms here in Santa Barbara. There's this one over here called My Care, which is what Cottage Hospital has released. It's a very standard form that you can fill out on your own. This is very, very easy to do. You do not need an attorney to do this at all. Everyone should do it. You can file it with Cottage Hospital so that they have it on record. You can also keep a copy in your home, somewhere very noticeable. People sometimes like to keep it right on their refrigerator. And make sure that your agent who's been named gets a copy of it, so they know these are this person's wishes, and they've asked me to make these decisions for them. Because what if that person doesn't want to make those decisions, you know? Have a conversation with them first. Make sure that they're okay to be put in that position. The advanced healthcare directives generally include the HIPAA authorization, which is what allows doctors, hospitals, and insurance providers to share your medical information with these agents. So that's just an important part to be aware of. And now the California statutory power of attorney. There's actually it's a very long name, the Uniform Statutory Form Power of Attorney is the full name. And this is what you use to give another agent. Doesn't have to be the same agent, because maybe the person who's making your healthcare decisions is terrible at managing money, right? These could be two very different people that you nominate to be these agents. So your power of attorney is going to be allowed to pay your bills, manage your bank accounts, deal with insurance claims, things like that, your daily financial life. The important thing to note here is that it must be noted that it is durable in order to be effective if you become incapacitated. And this is often when this is used. Sometimes powers of attorney are used when someone simply wants to give another person authority to sell a property or make some other sort of financial decision, but they're still fully they have capacity, you know, they are competent. A durable statutory power of attorney gives someone the ability to become your agent when you no longer have capacity. And that's when this is really, really critical, okay? Feel free to speak up, by the way. If you have any questions as we're going along, all right, I invite you to ask as we go. Without a plan in California, what can happen is that a court-supervised conservatorship can be required. And these conservatorships, I've got a bunch of information over here about them. They are lengthy and expensive, and they are public proceedings, and they create a lot of stress for families. And these conservatorships are where the court steps in to appoint someone as your power of attorney because you have it, and someone needs to do it, and we don't know who else to appoint, right? Now, the other thing is, what happens if you die and you didn't have a plan? Then the court steps in, and this is where there are the intestate laws of succession that the court will administer. And generally, those intestate laws mean that your spouse will first receive. After that, your children would receive, and if there is no spouse, it would all go to the children. If there is a spouse and there's children, things get divided up. But if there are neither of those, then it goes to your parents, if they're still alive. If they're not alive, then to any siblings that you have, and then it keeps going on to more and more remote heirs. But that's how the law will step in and decide who will get what you want if you haven't made any decisions at all. And that's not always a good thing. You know, I mean, there are a lot of people that for one reason or another, they don't want their spouse to get everything, or they don't want their kids to get everything, or they definitely don't want their parents or their siblings or someone like that. Maybe they're already, we don't have to think some bad things, right? But maybe they're already well taken care of, and they know that there's actually an aunt or a cousin who really could use their support a lot more. You know, it could be something that's not a worst case scenario type of thing. There just could be better people that they would like to see their assets support after their death. And this is also where charities can come in, and the church could be a beneficiary, other nonprofits that you support, things like that. You can name these sorts of people, but not if you don't have a plan. So we talked a little bit about conservatorships. I just wanted to make it a little more clear here about how difficult it can be. But there are lots of reasons that conservatorships are a good thing. Sometimes it is helpful for someone who lacks the physical or mental capacity to make their own decisions. And there are times when courts will step in and take this sort of control. And it's not an easy process to go through. And it can be an expensive process to go through. And so here's a little look at what happens in the probate process. This is what happens if you have a will, even. Your will have to go through probate. So whether or not you have a will, if you have a will and you pass away, you die what's called testate. If you die and you don't have a will, you die what's called intestate. Either one of those situations have to go through the probate process. So here you can see it starts where the will is authenticated, or maybe there's no will, so we skip that step. But you still go to court then, and maybe either the will names who you wanted to be your executor or personal representative to help administer everything, or the court will appoint someone if you died intestate. And then we go through this whole process before the estate is distributed. And this process right now in Santa Barbara takes about 18 months. And it's expensive. So when you have to go through a whole probate process, there are statutory fees that apply. And I should have written this down. For memory, it's 4% of the first $100,000, 3% of the second $100,000, 2% on the next $800,000, and then 1% after that on the top million. That's if it goes through a full probate. That's what the attorneys will take, and then the executor can take fees as well on top of that. So it gets incredibly, incredibly expensive. For example, We just had a case recently. The woman had approximately $750,000 worth of assets total. The statutory attorney's fees were more than $15,000. Do you know how much it costs? It would have cost her to create an estate plan? A few $1,000s, maybe, and then maybe a few thousand more to have a lawyer help administer that plan. You know? So the savings is very, very real. So that's kind of the point of this whole conversation is we're trying to avoid probate, you know, and you'll hear that term and you'll hear people say that all the time, and that's what I really am trying to communicate. We want to avoid the probate process because it is the lawyers that benefit and the people that get in charge if they want to be greedy. I've seen that happen in my son's father's case as well. The person who was put in charge of handling things, she had no reason to move things through the process quickly because she was continuing to take fees and pay herself the whole time, right?
Do those statutory fees get like, so say there's the person who passed away's attorney and then beneficiary or theoretical, like people who would be in line to get it, does it get parsed up among all of them, or does that just go?
No, that's just that one attorney. Yeah. The beneficiary would be paying
For
their
their own.
attorney separately. Yeah. And depending on how things work out, they may or may not allow those fees to be reimbursed. So a simple will in California, like we said, it's a nice start. It's a nice way for someone to be able to say, this is what I would like to have happen with my assets. This is the person that I nominate to be the one to do those things. But even a simple will typically involves a formal probate process. Now, the only time that it does not involve a probate process, and we're going to talk about this a little bit more at the end, is if it's what it's called a small estate. And right now, a small estate is when the personal assets are under $208,850. And there was a new law that just came out, which was designed to help people on more modest incomes, that now also allow, if you have a primary residence that's valued up to $750,000. So those two numbers combined, your house is worth 750 and you've got less than 208,000 assets, then you can get away with a simple will, kind of. It's still a process that's going to have some minimal court involvement. I'm making my clients aware that because the law has changed and it's expanded it, this small estate in certain ways, it's helpful, but we still need to be a little cautious because the law could change. Again, you could make a plan today, and when you pass away, the law is different. So that's one thing to be aware of with estate planning in general. Your estate plan in general should be reviewed every few years, or if you know there's been a law that has changed, or if there's been a significant change in your family situation. You've gotten divorced, you've gotten married, you've had children, whatever it may be, right? Or you've inherited assets from your family or something like that. So having a will, like I said, it's a start, but it's not the best situation for everyone. For college students, like we're talking about, a lot of people perhaps in this community, it can be a great thing, right? Most of them don't have more than $200,000 of assets yet, so this is great. Now, when you create a will, one of the things that I wanted to get really clear on is please do not, no matter what you do, learn one thing tonight. Do not download a form will off the internet. I'm not joking. I have a client right now, and this is the situation. A man knew he was gonna pass away. So he downloaded something off the internet that basically was a fill-in-the-blank document, and he wrote in by hand his name, and then he put in who he wanted to be his personal representative and receive. And so he just put in the names of people. Courts detest these sorts of documents. They're what are called form wills or a hybrid will, because they're partially typed and they're partially handwritten. And the courts detest these wills for a reason. They are very easily created by fraud, right? So that's why the court is so reluctant to approve of this kind of a will. So, if you are in a dire situation and you haven't made a will and you haven't done anything, the best thing you can do, get a napkin, get a piece of paper, write a date on it. Say, this is my last will and testament. Say what you want to have happen and sign it and make it all in your handwriting. That is what's called known as a holographic will. And a court will acknowledge that and will, generally speaking, allow that to go through and be approved for probate, so that what you've written down there, those wishes, the court will say, we're gonna order that those are approved. As opposed to you dying intestate without a will, and then your heirs at law, right? You go through that order, spouse, children, parents, siblings, they get it, right? Does that make sense? Any questions?
Well, we are leaving at 7:00 p.m.
Yeah.
Is there a possibility you could send us the information, the presentation or something like this?
Sure. Yeah, I can definitely. Yeah.
One question.
Yeah.
State in California is the same any state?
No. Great question. So, the question was, is California law the same as every other state?
Yeah.
So if what you do here, is it the same in every state? And unfortunately, no,
No.
it's not. And there are a lot of interesting things that we do here in California, one of which is we are a community property state. So this is very, very significant when you are married, and it's very significant for young people. I think this should be taught in high school, because it's something when you are a young single person, you should understand what it means as you are moving through your life and becoming accomplished and starting to create your own assets. It's really important to understand what happens if you start commingling those with someone that you're living with, and all of a sudden you are domestic partners, and this person starts to say, well, half of all of what they had is actually mine. And that happens. I've seen it happen.
Even if the person have her own things before to get married, after get married, the things are forgot.
It depends. That's the classic legal answer. It always depends. Generally speaking, what you've had before a relationship is known as separate property. And when you come to the relationship, that remains separate property. However, if you start to commingle things and you share bank accounts, and income from your separate property goes into a joint account that you share, or the joint account pays for the mortgage on that property, or there's a business involved and there's it was one spouse's business, but then the other spouse is working in the business. These things become very, very complicated. Yeah.
And I have another question. Well, I am a lawyer in Mexico. This is the same thing.
Amazing.
If you get something before to get married, it doesn't have to be part of the community, right?
Yeah.
But if you get something when you get married, that is another thing.
Right.
So my question is this, is in California, because in Mexico, we can decide, we can get married separating the things
Mm-hmm.
or getting the things together, okay?
Mm-hmm.
So here, is always getting the things together, or you can write a contract or something?
Yes, it's called a transmutation.
Okay.
And you can decide, as long as it's executed properly, that, say you're married, but one spouse wants to purchase something just for her, you can agree together that that will be that one spouse's separate property. Yes, or vice versa.
Or if they both get married and they both have their own things, they can continue getting their own things, right?
They can.
Mhm.
It's just best then that you really keep all the financial things separate.
For your experience,
Yeah.
when you decide to buy 2, 3 houses or 4 or more,
Mhm.
which state more better, best?
Which
More-
state is
For,
better
yeah,
if you're going to be purchasing a bunch
Yeah.
of rental properties? I cannot speak to that because I'm not familiar with other states' laws in regard to, you know, I'm trained in California, I'm licensed in California.
only California, no.
I'm not licensed to
No,
practice
no,
anywhere
this
else.
is only here.
Yeah,
Oh,
yeah.
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 Okay, so I have a question.
Yep.
So I know that living trusts are for like properties and stuff, but like, do they also help? For example, let's say I have a car, and I have to pay the car insurance or the medical insurance. Does it also help with the car and medical insurance, or is it only have to do with properties?
Well, generally, and we're gonna get to this in just a minute when we talk about trusts. Generally speaking, the trust, most people will have what's called a revocable trust. And let me see, well here, we just talked about this. We talked about why unmarried partners need special planning, right? Okay, trying to skip ahead here. Digital assets, okay, let's keep that in part of the estate plan when we're making distinctions on who gets what. Make sure that the person that you want in charge knows how to access your digital assets, because otherwise that can create all sorts of complications. Young people, please do something. If you haven't done anything, at least get a power of attorney and an advanced healthcare directive in place. So here, living trusts. So to answer your question about when a trust would get involved with holding a car, that's very common. When we create trusts, generally they are called revocable. So you'll hear these terms, revocable and irrevocable. Revocable means that you can change it, and irrevocable means that you cannot change it. So most people set up revocable trusts, and these trusts become their own entity. And the person who owns the property starts to wear 3 hats. They're the trustor, the person who's granting the property to the trust. Then they also generally are the trustee. They're the one who gets to manage that property in the trust. And for their lifetime, they're also the beneficiary of that trust. So under tax law, for example, all of the assets of the trust are still actually considered assets of the individual, because you're using them pretty much just like you were before the trust existed, right? So when we set up these revocable trusts, it's very common that we'll put in the house and the car, and we'll name all the other assets we can possibly think of in there. So your question about insurance, this is great. So when we get insurance on a house, we would want to make sure that the insurance company knows that it's the name of the trustee or the name of the trust that's insured, that's actually a really big deal, because we don't want the insurance company coming back and saying, well, we had so-and-so insured, not the trust, and you're saying that this is a trust asset. Which is it, right? In terms of the car insurance, generally that is still done just personally. Because even though the car is technically held under the trust, it's one of these smaller assets. Really, we're looking at small estate threshold. For things that are smaller under there, we're not overly concerned with having to get those into the name of the trust, because even if you have a trust, that small estate affidavit is what we use. It allows other assets to come into the trust just through affidavit without having to go to court and go through the probate process. And generally speaking, your insurance is going to insure you personally as a driver as well as your car, right?
Yeah.
So that's really, does that answer your question?
Yeah.
Okay. Anybody else? Yeah.
Can you briefly talk about the difference between a living trust and a will?
Yeah. So a will is a simple document generally that says, I, so-and-so, am a resident of this particular place, and this is who my family is, and this is what I want to have happen with my property. And then it's signed, and it's witnessed by two people who are called disinterested witnesses, which means they're not someone that you've just named to be taking assets under your will. So for example, if you're going to leave everything to your husband and daughter, your husband and daughter cannot then also be the ones that witness the will,
That's right.
okay? And again, it's for fraud reasons. We want to make sure that there's nothing sketchy going on.
One,
That's the technical term, of course, sketchy. Yeah.
you said two disinterested parties? What,
Yes.
Well, one's not enough, or
No,
is one?
one is not enough. You need two. Yes. And that's a big deal. All of your other estate planning documents will generally be notarized. They will be notarized in order to make them operative.
Yeah.
But your will, it
Doesn't
doesn't
have
need to
to
be
be.
notarized. It needs to be witnessed by two disinterested people. Yeah.
And then the trust comparison?
So the trust then, so when you create a trust, we also create what's known as a pour over will, because you still need to have a will. It is very, very important that you still have a will. This, however, is known as a pour over will. And it basically says, I, so-and-so, give all of my assets to my trust. And your trust, when we created it, it already became the owner of those assets. And so this pour over will, it's like if there's anything else out there in the world, like the car that we didn't maybe get in somehow, we're double checking that everything that I own is going into that trust. So that's the pour over will. And then it's the terms of the trust that control the distribution. And one of the things about that that's such a big deal is that that process remains private. The probate process that goes through court, not only is it lengthy, like I said, 18 months, those statutory fees can kick in, it's also public. And everyone who is nosy, and people are nosy, it's out there for them. With a trust administration, it's all done privately.
Including the portion that's subject to the probate or the pour over will, or that goes through court?
Yeah.
But it's less than the 250, so it doesn't.
No, the will will still get lodged with the court. Whenever someone dies and they have a will, it will get lodged with the court, but no formal probate should need to be opened if it's done properly. Yeah.
I have a question. So if, for example, we're in the process to sell some properties in Mexico, those properties are for her. So, we still don't have the money here. We are in the process,
Of selling,
selling them
Yes.
and getting the money here.
yes.
So, can we start preparing the trust even if we haven't received the money?
Yes, and do you have any assets in the United States?
Not yet.
Okay,
Everything is good.
so
Well, I have my school here, yes.
that should be in there.
The
That,
trust.
in the trust. So that's another thing, if you have LLCs, S corps, C corps, things like that, those can all become trust assets.
But
Right.
also have a will, right?
Yes, a pour over will, you wanna have both. But in order for a trust to legally come into existence, it has to be what's called funded. So you have to give it something to hold. So if you don't have anything yet, and you're just sort of creating paperwork,
That's what,
doesn't really exist. But if, for example, you have a company here, and that company is an LLC or a general partnership or whatever it might be, that interest can be held in the trust, and then you funded it. Yeah, and then if you acquire assets later, then we can look at things and make sure that those are, if you're buying new properties, that those get titled in the name of the trust properly. Or if you're just bringing in money and you've got large bank accounts, right? If you've got a bank account that's got over $200,000, the name on that bank account should be your name as trustee of your trust.
Oh, even for the bank account?
Yes. Yeah. See you all thinking.
So,
Wheels are turning. Yeah.
he's asking if so for the trust, we need a person who administrates, right?
That would be you. So you are the trustees of your trust. This is where you wear 3 hats at the beginning. We talked about having a whiteboard. This is where but that's okay. We don't need it. You want it? Okay. Yeah. So yeah, these 3 roles that you have when you create a trust, which is, one is the trustor, who's giving your assets to the trust. 2 is the trustee, who's managing the trust assets for your benefit, because you're then the 3rd hat is you are the beneficiary. Here, love it. Okay, we'll get a Sharpie and we'll draw this out, because it is helpful to see. Yeah, perfect. Thank you, Master. All right. Okay. We're gonna go with purple. So yeah. So these are your trustor, trustee, and beneficiary. Okay?
I was about to look at
Yeah, great. Thank you. Okay. So does that make it a little more clear? Yeah?
But, and then, so when you do living trust while you're alive, you're all 3 of those, but
Yeah.
then you, in the living trust would say, I want so-and-so to, you basically define all of those for after. Well,
Right.
trustee and beneficiary at least.
So, starts out, and it's you for all of them. But when you either pass away or you become incapacitated, you have your successors here, right? And it could be successor 1 and 2. You could name 2 people or 3 people, right? And then you also have your beneficiaries. So after you die, who gets your things? Is it gonna be family? Friends? Or charities, generally speaking? Yeah?
So the trust can still continue to operate with the different beneficiaries and the different trustees?
Well, generally, after you would pass away, then the successor trustee would step in. But if for some reason, the first one that you've named either isn't available or just doesn't wanna do it for some reason, then your number two would step in. And at that point, they will distribute the trust assets to these people under the terms that you have given them in the trust.
But what if you don't, but is it possible not to have the assets distributed and the trust still continue to function?
Yes,
Okay.
there are certain times, absolutely, where the trust will continue for someone's life. And in that situation, this is getting way more nuanced than just sort of like a basic estate planning. But sometimes a trust can create, it's kind of like having a trust within a trust. Hang on. Oops. So say this is a trust for person X. And that trust then could go on for person X's life. Maybe it's not uncommon where you had separate property. You had a house, say, and your husband outlived you. And you know, you're pretty sure that he might outlive you for some reason. I'm so sorry to pick on you. This is totally hypothetical. Okay? But for some reason, you have this house, it's your separate property, but if you were to pass away, you would want to make sure that your husband could live in the house for as long as he was alive. But ultimately, when he passes away, you want your daughter to be the one who inherits the house. So, your husband here then would have a trust for his life that was just regarding the house. And after he passed away then it would go to your daughter or whoever else you wanted. So that's one very common way to do something. There are other ways, I mean, I've seen lots of different trusts for life for people that come in. Yeah. Sometimes it's that they're a parent or parents, they set up a trust and they make their children the beneficiaries. But I've seen this happen. One of the daughters has no financial capability. She just is sort of all over the place. One of them is married to the guy who has a gambling problem, and they're really worried about that situation. One of them's married to someone who has severe health issues. And so they're worried about how, that could wrap up. And really, they're most focused on wanting their daughters to be taken care of. So they will leave their daughter's inheritance in trust for their life. Right? So yeah, that's not terribly uncommon. Any other questions?
I have here something very interesting about the owner of the Castillo, San Simon, the Castle.
Oh.
Castle,
Uh-huh.
what's the name of the church, the church?
Oh, yeah, yeah.
And I have written all the trust he created, even 50 years. For 50 years, no one can take anything, just getting the money.
Oh, wow.
Every month. And he made it for even the third generation.
Yeah.
But after 50 years, they can get their own parts.
This is Hearst Castle,
Yeah.
she's talking about.
Yeah, History
Yeah.
Channel
Wow.
He's the owner of many
New York
TV
Times,
channels.
Washington.
Yeah, yeah.
A lot of money.
Yeah.
Actually,
Yep,
yeah, it's good.
Yeah.
Good.
yeah, yeah.
Yeah.
All right. Any other questions, thoughts?
It's one idea.
Okay, well,
Amy?
yeah.
When you're talking about a beneficiary, can you use a married couple, or does it have to be in one or the other's name?
No, it could be a married couple. You could say that I give it to X and Y to take equally, or to one of them if the other is not living. Something like that, right? A lot of legal language is long because it's trying to look out for all the different possible scenarios that could happen, right? Which is also why, like I said before, every 3 to 5 years, generally speaking, you want to sit down and have a good review of your trust document with your attorney in case, one, the law changes, which I know we haven't talked about this yet, but right now there's what's called the federal estate tax, and it's very high right now. It's, I believe, 13.99 million for an individual, so say 14 million. So for a couple, they have to have $28 million before there's federal tax. But if that were to change and go back to what it was previously, there are also ways that trusts can come in to help make sure that the taxes are minimized. So right now, it's not a problem for most people.
One question.
Yeah.
Es irrevocable or irrevocable? And one. Pound California
Irrevocable living trusts are often used to
is
avoid.
irrevocable or irrevocable?
Revocable, well, or irrevocable. Both of them avoid probate. Yeah, yeah. Any kind of trust will avoid probate.
For 99 years.
Yeah, yeah. exactly, exactly.
Yeah.
Yeah, yeah. Okay. Any questions about this before we move on? I was gonna just show. I think we're just about done.
working with you, yeah?
What's that?
We are working with you, yeah.
Oh, great.
Our system, yeah, trust.
Great.
Yeah.
Great. I'd love to
You
help
offer
you.
here, office here?
Yeah, I do.
Yeah, it's okay.
It's on the card.
Yeah.
Yeah. Yeah.
Let me.
Yeah, I was just gonna show you, I have there's more information. I started a blog recently on my website because, and feel free,
Oh,
go. But I just wanted you to be aware,
Everything gonna.
that is, on my website, I have about 15 or 16 different short articles, but regarding a lot of the things we talked about tonight, and a few things that we didn't, but as a way to just provide some more education. That's really my intention tonight, is to provide information and education.
Thank you.
So, you're so welcome. It's very nice to meet you. So nice to meet you.
Maybe 8 months.
Okay,
When you have. in office,
I'll
yeah?
be here.
No,
I'm not going
I
anywhere.
will pray for us. Yeah?
Okay, yes, good luck.
Yeah.
So just one last announcement. Oh, just while we have friends that are current to the bar, can we just give a round of applause to Amy and the presentation tonight? Very, very grateful. I just wanted to also let you know that Essa was able to drop off some spaghetti and meatballs. That's also available. So before you depart, please make sure you grab some food, grab some love.
Yes, indeed.
Again, on behalf of Amy as well as Yumi Ivy, we just want to extend a just warm gratitude for each and every one of you being present here. Please make sure you pick up her contact card that she has
We
available.
got it.
And then if you get the chance, before you sign out, Amy will hopefully have this PowerPoint slides available,
Sure.
just so that we'll email it to you. If you can, just fill out your email, and then we'll make sure we get that information sent to you. But Amy will continue on with her presentation, but I just wanted to.
We're done. That's a great way to wrap it up. Yeah, yeah. Thank you so much, Pastor. This has been wonderful.
It's
And
okay.
thank you
Can
all.
we just give one
Yeah.
final round of applause for Amy?
Thank you.
And so we just want to let you know know again, the Legal Literacy for the Community program will continue to be held every second Thursday of every month. And so Amy will be sticking around for the next couple of minutes if you have any questions that you just want to engage with her. But again, we just want to extend a warm gratitude for each and every one of you being present here today.
Yeah, and I think also we're gonna do this topic again. We were talking to Teresa about doing it again later in the year. So if you learned something here that was valuable and you want other people, bring them back next time, please. Yeah. Yeah, thank you.
So, hey, God bless you all. And so again, make sure you grab some food. Here's the thing, but thank you all again for being present here tonight.
Just disinterested from the well, so it can't be like, you don't get some kind but it's open.
And she said that with people, and you
So
I'm gonna get you some card in that, I just wanna try to get this.
I heard you at yoga.
And meditation. How was it? And honestly, I'm back in this like world, and you know, everything is like just like, oh, everything I do. I'm not any of you right now.
You're still there.
There.
Yes, that's great. I love that so much.
Yes, and even though the yoga part was a little bit more work.
Oh, okay.
It wasn't so strenuous, and I felt the need to stretch really, really far.
Oh, nice.
But you know, it's he's a dancer and I'm like uncoordinated and I wish there was like CCTV so I can see, understand what he's saying and be there as he's doing, but I just watched him and like, but it felt great.
Oh my gosh.
But I'm still not here.
Yeah, I get it. After I
After
finish yoga, I'm often like that too, like for at least like a good 30 plus minutes, like still trying to transition.
This is just off script, but I just wanted to let you guys know again, the next Legal Literacy for the Community will be on April 9th. And what we will be talking about is insurance policies. Okay? Insurance policies. And we actually penciling in our guest speaker right here. And so he's just going to share his name real quick and then just some hopeful information that will be presented on April 9th.
Thank you. How you guys doing? Hi. So let's talk about insurance next month, April 9th, right? I just received that notice 25 seconds ago. I'm gonna put something together and hopefully you guys can come. And if you know more people that are interested about the world of insurance, please bring them along.
So important.
So important.
So important.
It's okay. Representative Gabriel.
Gabriel.
Thank you.
Do you work for a particular
Farmers.
Thank you.
I work for farmers
Yeah, I
insurance.
feel like when I wasn't able to get
Farmers
away.
Yes,
It felt great, but yet it felt like I didn't get away.
I get that.
And then, so I was still amongst everybody, and, you know, everybody, people like open their eyes, and there I was just kind of like, okay, who cares if they're open their eyes or not, because I laughed. So good.
That's great.
And so, I mean, I know you do your own yoga and you do your own
Yeah.
but, you know, and they both just started doing it.
Oh, that's cool.
So it's kind of not
So we canceled last month.
like be a great meditator receiver, yoga, you know?
Yeah, yes.
It's like if I mess up, it's like, I don't know, I feel like it was okay.
Yeah.
But it's, and it was, I don't know if people do like
Yeah.
was targeted before, like it's
Oh,
for
yes, he was
everybody.
telling me.
But
That's great.
It's for everybody who does, and he goes out there and helps people no matter what it is.
Yes, right,
And
right.
they just, they're caregivers.
That's so great.
They're like, everybody needs care.
Been a great guy.
Self It didn't feel like self-care, but I guess it is.
It is because you make the conscious decision to go. That's usually what like people, or you should remind yourself if you're going to yoga. It means like, wait, I made I could be in bed, I could be scrolling on my phone, but I decided to do something for myself and for my health. Yeah.
Through it all, there was a moment where I thought about you and I thought, oh my gosh, I fell asleep. But the rest of the time, I didn't respond.
Yeah, okay.
I did. I thought about you.
Oh my
You
gosh.
came into my mind, like, people were coming, like, wandering into my mind.
Yes, that happens all the time. Yes,
You
yeah.
came into my mind. But it didn't really.
Yeah, we're looking forward to
I don't know if,
in a few weeks.
Thank you so much for sharing. I'm so glad you had a good
Guys, I need to know what I
experience.
want to talk
So
about.
you tell your mom and your family, like,
Yes.
because you
Give you my
use it,
card.
like, you know, they
I'll see
feel,
you next month.
and like, I was sharing, I think I shared something bad to you. I
No,
was like
no,
that, so.
definitely not. Yeah, yes.
You got me over more and more.
I'm glad. That's the goal.
You're so funny.
Thanks, Janet. This is great.
Very helpful.
So helpful. I'm kind of like, oh my gosh, I actually was sending pictures of to one of my friends. So I'm like, hopefully, she said she's coming back.
But yeah,
Hopefully
we
I
can
can
just
bring
do that for
someone
now.
next time.
But just
Yeah.
like
well, I look forward to talking with you more.
Yes, about
Over the
insurance.
amount
I should
or-
learn more about that too.
See ya.
All these topics I need to be learning more
public,
about.
whatever. So there's some exceptions for primary residence now.
Yeah.
Not trouble because of I just think at this point it's probably for the rest of them to do it within the next week.
What states was it?
She said that she was, she said, I'm gonna bring the food over.
Over 10 minutes. Oh it's not worth his time for that. Well, he knows somebody, yes, absolutely.
But I feel like when you think about it, because I think I have.
And they record it.
Yeah, I'm not in a rush to do it. I'm not saying you're I'm sorry, you don't worry about it right now. That's great. Next time I want to do it. It's not my piece. Those are your pieces. They're my pieces. Well, but I can't drive you home and you're in both cars. What? Yes.
I was trying to think of like what's happening. I will be here. Yes. So I'm
Hi, I wanted to say hi.
My wife says.
Get to meet you before. Beth, was it? Oh, Beverly. Nice to meet you.
Oh, two.
Yes. Yeah, my pleasure. Take care, you guys. Well, you know, I wish I could help you more, but I don't know people in those fields or places. You know, my suggestion, I look people up and see who has good reviews. That's something worth doing, you know? And it's at least a starting point, you know? Yeah,
But that's a different. But I was just saying.
well, it is a life estate though. That's the same thing. If it's a trust, I mean, if that's what that is, if it's like a trust for a house, you know, for the benefit of someone, then that is a life estate.
Is it called a life estate if there are other assets that aren't residential that, just keep
It
going?
can be.
Okay.